Welcome to today's webinar. We're going to start in just a couple minutes. Welcome to today's webinar. This is Mark Donovan from Control, and this is the fourth part of our six-part series, an Introduction to Information Governance series. If you've been with us some of the past webinars, we've talked about an introduction to information governance, records management, and last time we talked about privacy and data classification. Today we're going to talk about achieving litigation readiness. And to talk about litigation readiness, we have Tom Mile with us today. Tom is Vice President of Delivery with Contoral. He's an attorney. He's actually a former litigator himself, and he's fairly active in the legal community. Welcome, Tom. I appreciate you spending some time with us today.
Hello. Good morning. Good afternoon, everybody.
So, Tom, it's interesting. Today we're going to talk a little bit about litigation readiness, but that's different than eDiscovery. I hear a lot of talk about eDiscovery, but a little bit less about litigation readiness, and I guess those things are different.
They are different, and they're related. They're similar, but they are different in that litigation readiness is another piece of the information governance puzzle. So it is another way in which organizations need to make sure that their information is managed properly for a particular purpose. In this case, being able to respond in litigation, which is the eDiscovery process. So eDiscovery and litigation readiness are kind of hand in hand, but the litigation readiness needs to come first. Otherwise, otherwise you have some of the problems that I think we're going to talk about in this session. What we want to talk about here is understanding your litigation profile and that it doesn't matter what your litigation profile is, that you need to be have a level or a status of litigation readiness. Kind of understand why that's important, why it's important not only in eDiscovery but in other matters where you may be required to produce information. We'll talk about some of the basic steps to become litigation ready, and you will see how closely aligned they are to all these other information governance steps we've been talking about during this series. And then we'll finish up talking a little bit about some of the eDiscovery tools that you can use to help respond if you ever are required to produce information as part of a lawsuit or regulatory investigation or some other matter.
Okay, so we get this question sometimes, and we talk to a lot of people, and some big companies have an awful lot of litigation, but I talk to a lot of people who says, we don't really have litigation. Talk to records managers or other ones that say, no, that doesn't really affect us too much. What are you seeing out there?
Well, I think it's really interesting because this is what you see here on the screen is from Norton Rose Fulbright's annual litigation trends survey. This is from 2017. It's really a very interesting survey because it's a survey of in-house counsel who are talking about the types of litigation that they get and how they're dealing with it. And what's really interesting to me, the two stats that are interesting from this survey are the fact that one, most companies don't have a lot of litigation. You'll notice here that over 50% of the respondents either have zero or 1 to 5 lawsuits per year, and that's pretty darn good. The rest of them go up plus, and only a quarter of them have more than 20 lawsuits per year. This actually consistent with a lot of the companies that we work with. They just don't have, and knock wood, they don't have the litigation profile where they are needing to where they're needing to respond to eDiscovery on a regular basis. But let's turn that around a little bit. And next slide. Even though most companies have small litigation profiles, all companies have litigation. There was somebody there who says 0, but let's be honest, there are claims, there are different types of matters that you get in. And this is the other statistic from the Norton Rose Fulbright survey that talks about what the different kinds are. Most organizations have labor and employment. Contracts will be that close second, and then it kind of divides up evenly among the other different types of litigation. So you may recognize that this type of these types of lawsuits are matters that you may be handling on a either regular or semi-regular basis. But this is what we usually find, and I think with most of the organizations we work with, contracts, labor and employment cases tend to be most frequent. But there are lots of personal injury, lots of products liability, intellectual property cases that require the production of lots of information often. And that's what we want to talk about here today. And I think the challenge with this is that you may have litigation, but problems can happen to anyone if you don't pay attention. So I would argue that the organizations that actually need to be litigation ready the most are the ones who have litigation the least. The organizations that have 20, 30 more cases per year that they're dealing with, they get the practice. They're practicing their litigation readiness all the time. They have something down. It's the organizations that don't have much who sometimes find that litigation, the process of responding to requests for electronic information, can become somewhat of a fire drill. It can be something that they need to think about, how do we do this every single time? And here's one way. If we go to the next slide.
Well, and this brings up the question, Tom, which is, we hear this a lot of times. Listen, because we have so much little litigation, we are going to only actually deal with it when it happens. I mean, I got lots of things to do. Why do I need to spend time on something that probably won't happen to me, or may happen to me very little?
Well, we're gonna talk about that probably in more detail in a little bit, but it's all about, and there's a slide coming up here, it's all about firefighting versus fire prevention. Would you rather be spending lots of money and effort fighting a fire, or would you rather spend some effort up front fireproofing your process? And that's, I think, really the best analogy there is if you have a consistent, repeatable process in place, and if you have good information governance practices behind that process, then responding should be much more straightforward. It shouldn't be the fire drill. It should be something that you can respond to in confidence when it happens. So we have this example here. This is an example of a manufacturing company, not a lot of employees, about 750 employees. Like we've been talking about, historically low litigation profile. They get a nuisance lawsuit that they believe doesn't have any merit. But you know what? They take it lightly. They don't really know exactly what to do. They don't put a good legal hold on documents. The plaintiff came in and said, Judge, they've not been taking care of their information the way that they should be. We need some help here. The judge agreed and said, hey, we're not sure we can trust you because you haven't given the right responses that you need to be given. So they ordered the company to hire a vendor to come in, search the information. They searched drives. They searched backup tapes. They presented the company, the defendant, with a $2.5 million discovery bill for all of that work that they wound up doing. And finally, once all the discovery was done, they put it all in front of the judge. And the judge says, you know what? You're right. This is a nuisance case. We'll dismiss it. So the judge dismisses the lawsuit for the low cost of $2.5 million for the company to pay in an eDiscovery fees. So that's why.
Now, Tom, we have a question. Even though the lawsuit was unsuccessful, was this company allowed to charge the plaintiff back for the eDiscovery, or did they face that themselves?
Well, in this case, they faced it themselves. I mean, the cost division in eDiscovery really depends on the circumstances. In this case, I suspect that the reason why the company had to bear the cost themselves is because they failed to adequately preserve the information. It was their action up front that caused the discovery problem. You know, if a plaintiff comes and makes a demand that's unreasonable, you know, we want you to go and find all emails that have this information in it, and the judge is persuaded that that is not really relevant to the case, the judge can order the plaintiff to pay for it if they really want it. So there are times where there will be cost sharing. There are times where the other party will bear the cost. In this case, it's on them. It's their problem. So they wound up bearing the cost of that production. So next slide. So one of the challenges, and this is actually another answer to the question that came before, which is why should I do this now if I have a low litigation profile? Part of the reason is that there are some things that are within your control and some things that are not within your control when it comes to litigation. You can't control how often you get sued. You can't control who sues you, what that lawyer or that party is like, and what they're going to be, what they have in mind. You can't control where that. You can sometimes control the venue, but you don't often have the ability to control the venue. You can't control the facts of the case right up front, and you also can't control the sophistication of the opponent. It used to be that lawyers suing organizations weren't that sophisticated about electronic information. Those days are long gone. They will hire an expert, they will get a vendor to come in or a company to come in and help out. Those days are really in the past. What you can control, and look at what you've got over here, there's a lot of things you can control that are related to information governance. One, you can control over-retaining information on legal holds, setting legal holds that are too broad, that cover too much information, and that require too much production. You're in control of early case assessment. Let's go take a look at what's out there. Let's go and sample the information and see, is this a case that we want to fight, or is this a case that we want to settle now and forego all of the costs of discovery and litigation? How much information do we have that we're going to have to send to outside counsel and review them? Again, a good information governance program should help to reduce the volume of documents that outside counsel needs to review. The ability to argue proportionality. You can argue that we should only be required to produce so much information because that's what this case is all about. That's a recently new amendment to the rules, and I think it's a good tool for organizations or people who've been served with a discovery request, and you do have that within your control. Is
that what you mean, Tom, by proportionality?
Proportionality means is that a requesting party cannot come in and basically ask for a fishing expedition. They can't say, we want to see every single document you have that could possibly ever be related to anything that we want to talk about ever. It has to, the document request has to meet the value of the case, the matters of the case. There's a lot of factors that go into proportionality, but the document request and what you have to produce should be proportionate to the size of the case, the subject matter that you're talking about, and there needs to be some level there that a judge is going to find. This is how much you're entitled to go get, plaintiff or discovering lawyer. This is what you'll be able to go get, and that's what's generally considered to be is proportionality. You have the ability, it's in your control to assure that all the documents, all the right people, all the right repositories have been identified. It's in your control to have a defensible process. That's what we'll be talking about today, is making sure that process is defensible. And then if we're talking about federal cases, but then certainly to a certain extent in state court as well, it is in your control to be ready. That's part of what a meet and confer is about, is to understand and be able to talk about, here's what we have, here's the information that we're ready to produce or that is relevant to this, and that also is something that is very much within your control to be able to do. That's why,
Tom, what's a meet and confer?
Yeah, sure. A meet and confer under the federal rules is a meeting that is required by the judge in most cases that requires the two parties to get together and discuss certain elements of discovery. What will be produced? What format will it be produced in? Who is going to testify about systems if we need to talk about computer systems? It's really sitting down and reaching some level of consensus over the scope of discovery. You have to be able to show that you've had a meeting. There may not be agreement on everything. In that case, you take it to the judge, but there has to be a good faith effort to talk about what you have, what you're able to produce. Having good knowledge of that is important. So that's mostly in federal court, although some state courts will also require you to have a discovery conference or something similar. So let's talk about, and this is actually the newest version of the electronic discovery reference model. If you've not heard of this before, this is the model that covers the life cycle of electronic discovery. Now, I'm going to pay attention to the middle to the right for right now, and then I'm going to spend the rest of today basically talking about the left part. But you'll notice that there are 6 main phases. There is the identification phase, which is understanding who your custodians are, what the repositories are that hold relevant information, making sure you know where all the stuff is located and who has control over it. Preservation, you probably know, is implementing a legal hold, making sure that all information is properly preserved for the time that you need to then go collect it, which is the next phase. We're going to collect that information. We want to make sure that we're collecting it in a way that doesn't alter the information, that doesn't inadvertently change it or destroy it. And we want to make sure we collect it and put it into a place where it can be stored until it's time to do the next set of things, which is processing. We're going to take all that information, deduplicate it to make sure that we're not giving them duplicate information, make sure that there are no irrelevant documents that are in there, clean out computer operating files and those types of things. Then it goes to generally outside counsel for the review process, where they'll review it for both privilege and responsiveness. There will be some analysis as part of that. And then generally the production phase. Production is producing it to the other party, to the investigator, to the regulatory authority who's dealing with that. And then to the extent you get to trial, presentation is that last piece. What's interesting is that information governance really starts at the beginning of this. And when this diagram was first introduced a number of years ago, that information governance box was about the same size as all of the other boxes that were listed there. I would argue that the proportionality of how important information governance is to the eDiscovery process is demonstrated very much in this diagram. And it argues that if you want to have a defensible, economic, efficient discovery response process on the right side, you have to have good information governance practices from the beginning on the left side and moving forward throughout all of the discovery process.
And Tom, let me just add a couple comments to that. This entire model is from edrm.net, which is an organization that produces this. By the way, we're really not crazy about this IG model on the left.
Right.
We've seen it a lot. I don't think it's informative. I think there's better ways of communicating it than they have on there. But the other thing that comes up is I always know when I'm talking to an eDiscovery vendor, because they go, "Oh, you do the left side of the eDRM." A lot of eDiscovery people look at this as their world, and they look at IG as this little thing, this little process you stick at the beginning, on the left-hand side. No, eDiscovery should be the last mile. Most of the effort on managing information goes ahead of this, and that can reduce it. But depending on whom you talk to, oftentimes an organization's view on eDiscovery is, oh yeah, IG is this little thing that you add on the part of it. The other thing I'm going to add to this is sometimes, by the way, there is an incentive by law firms and eDiscovery firms to avoid having you become litigation ready. Sometimes they're not very forthcoming on advice. And it's pretty simple. The least ready you are, the more data you have, the more stuff you have over there, the more that they have to process, review, identify, analyze, and produce, the more money they make. And so there's sort of a culture within the eDiscovery industry to being completely reactive, saying, well, we'll just get there because there's a financial incentive to do that. Fortunately, many companies are saying, no, we're going to save a lot of money. We're going we're going to be smarter and get control of this ahead of time versus just wait till there's a fire raging and then we'll put it out. There's a better approach to doing this.
Well, and to add a little bit more color to what Mark said, this is, and to respond to a question asked, yes, this is not a contour model. The electronic discovery reference model was put about by an organization called EDRM.net. Recently, that organization was, I'm not sure the right word is acquired or whatever, by Duke University Law School. So the electronic discovery reference model is more of a think tank about best processes, best practices around electronic discovery. It's mostly within the Duke University Law School. And I agree with Mark entirely that I am not a fan of how it describes information governance. The reason why I like this so much is that it finally gives information governance the importance it deserves, because for many, many years, eDiscovery vendors and lawyers were talking really only about eDiscovery, not realizing that information governance is that important, critical thing that needs to be taken care of. And I think now it's really being given the credit that it's due, even though they might not all have this organized in a way that's simple or necessarily accurate about how information governance is handled.
And to be clear, from the red box to the right identification, we think that it's a very useful model. It's just that little circular diagram that describes information governance.
Yep.
I presented that many times in front of senior executives, and they've said, huh? And so we gave up using that. We use different models or different graphics when describing information governance.
Yep. Next slide. So the next couple of slides I want to talk about are about why it's important to be litigation ready in the event that you have to respond to something. And it's not just litigation that you have to worry about. Here, this is the general rule in federal court around the meet and confer. Once suit is filed, you have a certain period of time before you have to have your meet and confer. You've usually got to have that within the first 90 or so days after that lawsuit is filed, and that's what the court is going to expect, which means even though you might not be producing everything, even though you might not be actually discovering and actually conducting discovery, you actually have to have a good idea of what you have and how you plan to argue your scope of discovery during that period of time. That's why having a good plan, having all your information governance ducks in a row is so useful and helpful, because it helps you respond faster and be in a place where you can respond. Now, here's another place where that's important. If we go to the next slide, not all discovery is about litigation. A number of you have to deal with Freedom of Information Act, or if you work for a public agency, you're doing public record requests. You may have some mechanism where you have a relatively limited amount of time to take the information that you get, to figure out where it is, and to figure out how to get it, how to review it, because sometimes you've got to review it, and then how to get it out to the person. The Freedom of Information Act, a very similar process to litigation, because you're having to go find stuff that you may have, find records and information, review it, and produce it outside. And the place that we're seeing this happen most frequently and most recently, or we're about to start seeing that, is if we go to the next slide. Now that Okay, go ahead.
Tom, let me just add one quick comment on this slide. By the way, if you face either state or local sunshine laws or public records requests, this is the FOIA. This is for federal agencies, but very similar laws, a lot of similar processes if you have either state or local public records, your public sector organization, you have to find it. So FOIA is for federal. A lot of times we talk about FOIA, what we really mean is a sort of a catch-all for all the public records laws out there.
So if you are required to respond to GDPR, if you've been doing your GDPR preparation, or you now find that you may have some requirements to comply with the California Consumer Privacy Act, or CCPA, you may find that there's yet another place where you're going to have to learn how to organize your information so that when a request comes in for it, you can search for it, you can find it, you can review it, you can organize it, and you can turn it over. With the CCPA, That's actually a broader process. It's about tracking that process, tracking that request. The request will generally be, can I see my personal information, or will you delete my personal information? They've got to authenticate that, make sure that that's coming from the legitimate person who owns their own personal data. But the piece down below is something that we are going to see a lot of, and with regard to California consumer privacy, and it's really not that much different from eDiscovery. It is, how do we search for information in our organization? How do we then either review it, produce it, and or delete it? That's what privacy is going to happen. Obviously, with eDiscovery, you'll be producing it to another party, or you'll be deciding that it's not relevant and you're not going to produce. But the process essentially remains the same regardless. So a lot of different regimes, a lot of different venues are going to require you to have the same type of readiness practice to go through it. This is mostly talking about litigation, but it really could apply no matter what type of regulation requires you to produce information. Next slide. So we want to talk very briefly about legal holds. Legal holds are, if you have a good retention policy in place, the retention policy should essentially say, at a minimum, it should say, we're going to keep our records for a period of time until the retention schedule tells us we no longer keep those records, except when there's a legal hold. And when the legal hold comes in, then all bets are off, and it supersedes the record retention destruction date. It supersedes any requirements around management of any relevant records under legal hold until that legal hold is lifted. What we usually see in the average legal hold, and what should be communicated not only to the individuals who might have information that's relevant, but also to the people who might own the data repositories, in case there are systems or file shares where deletion is going on a semi-routine or routine basis. You want to make sure that that legal hold gets to anybody who might have a reason or a means of deleting information before it should be deleted. And they need to know all of this. They obviously need to pay attention to it. Usually a legal hold asks people to just go ahead and do what you're doing, because asking individuals to produce things generally, it takes up their time, generally doesn't get done correctly, and the courts don't always approve of that. So usually a legal hold will say, continue about your business, just do not delete, destroy, alter, or modify any documents that are relevant to the legal hold. So anything that might have any relevance to the case, you can't do anything with. If you can't edit it and save it as a new version. You can't alter it. You can't destroy it. You can't do anything with it. If you have to do things with it, we generally say, talk to the legal department, the person who sent you the hold, and get their advice and instruction for how to deal with that particular record. We always like to see policies that have a legal hold in place, and that you must follow until you receive a release of that hold from legal. And once that happens, then it's really back to normal operating procedure. It's if a record was being held according to the schedule, and for some reason that record may have expired, or that retention period may have expired while the legal hold was in place, you can then go ahead and delete that information. If it's not, then you just resume normal retention operations. But the legal hold really is a pause in the whole process. What we find happens most often are the overly broad legal holds, the holds that try and lock down way too much stuff because you're never sure what's relevant. You don't have a confidence that you're going to be able to go and search for it. So let's just lock it all down. And when that happens, organizations tend to take on and keep a whole lot more information than they need to. That's why having a good information governance program to be able to take care of and control your information can help you target and limit your legal holds so that you're holding less and you're able to get rid of and put the rest of your documents through normal record retention according to your policy. Next slide. So we come to the question, do you want to be a firefighter or a fireproofer? with reactive eDiscovery, you are accumulating information. You have those broad, those inconsistent legal holds. You've got reactive eDiscovery. So we want to make sure that you're not reacting to something, that you actually have a plan, that you actually can put something together. We find that firefighting tends to be more out of control than the proactive, which is ongoing defensible disposition, understanding where your information is by doing some level of ESI or data mapping, having a consistent and repeatable in-house response process, and making that, again, I probably can't say this enough, it has to be a predictable, consistent, repeatable process. That's what the courts will accept. That's what they'll recognize. There's not a requirement of perfection here. Most courts only look for reasonable good faith efforts. There are so many electronic documents out there these days that it's entirely possible to miss some, and the courts recognize that that's going to happen. As long as you have a plan, as long as you follow it, as long as you demonstrate that we got something that we can do every time, and we are consistent about doing it every time, chances are you'll get much better results from a court in case something goes wrong and documents are deleted, or you have a problem with your discovery response.
So Tom, we've got a question here. At what point should we consider retention policies to minimize information open for eDiscovery? And I'll add a writer on that, which is to basically say, to what extent can you realize that you need to implement your retention, more specifically your destruction policies, when you know you're facing litigation? And that's a loaded question.
That is a loaded question, because you should have been thinking about it a long time before that. I mean, and I think, let's move to the next slide. I think that may be sort of predicting the best steps to good litigation readiness, and you'll see what's at the top of the list. The top of the list is a retention policy and schedule. If you attended the second class in this series, then you have a good idea of what's necessary to put together a good policy and schedule. But that's really got to be your foundation. You've got to be able to say, here are the records that we keep, here is how long we keep them, and then there's that next really ugly part, which is we need to make sure we follow our retention schedule, because if you don't follow it, you still wind up in the same place. You've got a document that says, here's what we've got to do, but you wind up where you didn't want to be, which is lots and lots of records that haven't been deleted. And we talk a lot of times about, is it better to have a policy that you don't follow or no policy at all? Well, in this case, if you have a retention schedule you're not following, it could go very badly for you in litigation. So having that policy, that schedule in place, and actually using it and destroying documents and making sure that they're going away when they're supposed to, that's how to become litigation ready, because you minimize your data footprint. So many organizations we work with keep tons and tons of information, and not just relevant records, but junk and all sorts of what we would call the rot, the redundant, the out of date, the trivial information, the stuff that doesn't belong there, and people are keeping it. All of that has to be gone through. All of that has to be searched and reviewed, and hopefully there are technologies that can help limit that. But if you're not using technology, or if you're relying on your outside counsel to do it, they may have to review a lot of junk before they get things out of there. Hopefully you're using technology in a smart way to do it, but that's the main problem with keeping things forever, is you have to produce a lot of it and you have to review a lot of it. So that's the first place. To get there, once you've got your retention schedule, one way of enforcing it is through a data placement strategy, is making sure that we put all of our unstructured information in the right places, in places where you can control retention, where individuals find it easy to put information. They don't have to struggle with, where do I store things? We give them a few options, and that's something that I think you would have learned in, I can't see this part of the screen, in a previous class, or is that the class coming up?
Class 5.
Class 5, that's class 5. I'm sorry, I can't see the screen from here. That's something you will learn in the next class, so please pay attention to that, because that is really the what do we do after we've got our schedule in place? It's let's put all of our information in the right places and control it for the right amount of time so that then when the retention period comes up, we can delete it, and it can delete automatically so we don't have to worry about it. We'll talk a little bit more about a discovery response plan. We've talked a little bit about the legal hold process. We'll talk more about the plan in just a minute. We've talked about data maps a little bit in the session just before this in class 3, but we're going to talk a little bit more about data maps in just a few minutes, and specifically how they apply to litigation and eDiscovery. One thing that you want to understand is what type of technology do you want to use? If your profile is low, you may not want to bring any technology inside. You may just want to have a vendor, but understanding when it's right to do it on your own versus bringing someone in is really a critical piece of getting your litigation readiness in order. And then finally, you will learn in class 6 something that we talk about all the time, which is if the people who are responsible for this process don't understand how it works, if the employees don't know how to use the retention schedule or who don't know how to put information where it needs to go, then all of this litigation readiness doesn't happen. You wind up right back where you were. So having training that educates people all the way along all of these pieces here is really critical to be able to let people know that one, we're going to manage our records appropriately, and two, if we do get sued, if there is litigation against us or some other thing, then we have a process that we now know how to follow. Go get that information, grab it, and be as efficient as we possibly can about it. So these are the basic steps. We're going to talk about some of them, I think, in a little bit more detail for the rest of this session.
And Tom, just a quick follow-up to one of the questions. Well, one of the questions posed was, can you selectively implement your retention schedule when you know litigation is going your way? We know one company that did that, well, other companies, but one company in particular did that, is where they had a retention schedule, they never implemented it. They were a large audit and accounting firm, and there were some questions over one of the companies they were auditing, and they said, by the way, we have all this stuff up there, we've never implemented a records retention schedule. So the attorney said, oh, by the way, start deleting everything. Follow the policy and schedule out there. Well, no, you're not allowed to do that. And the name of the company was called Arthur Andersen, and their client was Enron. It was, one could argue, it was that one email from their attorney, their in-house counsel, that said, and she should have known better, hey, we may be under scrutiny, go ahead and now follow the policies. It'd been fine if they'd followed the policies before they had anticipation of litigation, but because they did it when they knew that they were probably going to get sued, not only did that impact their ability to do the lawsuit, the public furor over that, basically Arthur Andersen imploded. I mean, as a company, it imploded. And so sometimes records management, in this case, poor records management policies, or in this case, poor legal hold and litigation readiness policies, literally, Enron was just one client of thousands of clients for Arthur Andersen, but it was enough to bring down, you could argue other things, but we would argue that one action was probably the one catalyst that brought down Arthur Andersen. So no, once you have anticipation of litigation or public records request, even if you could delete it per your record schedule, at that point you can't. Until that matter is adjudicated. So, and again, don't find out the hard way. Bad things can happen to you if you do.
Well, and it works both ways. So what we haven't talked about a lot in this session is what if your company sues somebody else? What are your obligations there? Because even though you may be the plaintiff, the other side is still going to ask you for discovery. They're still going to serve a request to produce electronic information. And there was a case a number of years ago where a company, which was apparently fairly litigious in terms of its protecting its own intellectual property, every time before they began to file a patent infringement lawsuit against somebody, they would affirmatively go out and have a records cleanup day. Let's clean everything up before we sue somebody so that we don't have anything standing around for when that happens. That was also found to be bad behavior because it was in connection with the lawsuit, and that's really the difference. Where you get approval from the courts is We have a policy, we have a schedule, we're following it routinely. We've been following it for a long period of time. We didn't just decide to start following it for this lawsuit or because we got sued or because we're getting ready to file a lawsuit against somebody else. Next slide. So I've talked around the whole notion of a discovery response process, and I will give a quick example about why what I like about this discovery response process. I hate to call it a glorified checklist, but in some ways, that's what it is. And I would urge you, if you haven't, I would urge you to go and read the book, The Checklist Manifesto. It was written by a surgeon in Boston who was asked to come into a hospital and reduce the amount of post-surgical infections that were really causing problems for patients. And he discovered that if he just introduced a checklist process into the operating room, that it would really have an effect. And that the doctors and nurses and everybody in the operating room, they really weren't sure about it. They thought, why are you questioning our abilities? And he's like, I'm not questioning your ability, I'm questioning your memory. I'm questioning that you may not remember to do everything you're supposed to. And so they finally implemented it, and after they had studied it for a while, they discovered that they had reduced the incidence of post-surgical infection literally down to 0. And so the power of having a process that you document, what we find with many organizations is you probably already have a process in place for responding to discovery. My guess is it's not fully documented. You may have a legal hold policy or a legal hold procedure, but you likely do not have a step-by-step guide that will take you from identification all the way through production that would cover any step that might occur to you, because it's not about the 99% of the cases that you have. It's that 1% of the what in the heck did we just get ourselves into that you're not sure what you might have. It's what are all the steps that we might need to follow, and then for each individual case, let's take a look at each step and say, nope, for this one, we don't need to follow that. We can skip past that. The other reason why this type of process and checklist is useful is it helps protect you against what I would consider as the winning the lottery syndrome, or if we're morbid, the getting hit by a bus syndrome, which is if the people that you entrust the discovery process to in your organization, lots of companies with small litigation profiles have a paralegal or one attorney or an attorney and a paralegal handling things. If for some reason they leave the company, they take all that knowledge with them about the process, and you have to start all over again. Having this documented process in place is incredibly important. And so it's about a checklist of the steps. It's about the right forms, not just a legal hold notice form that you send out to everybody, but a legal hold that you might need to send to a third party, a legal hold that you might need to send to IT to make sure they were doing it correctly, a legal hold release form to make sure that you send out releases. One of the things we find that law departments don't do as often as they should is actually release the hold for their employees. They celebrate internally, yay, we settled the case, but they forget to release the hold. Really important part, and it's included on that checklist. Having the right type of documents and forms for collection of information, making sure that you are preserving a chain of custody when you collect electronic information, so that there can be no question when you get to trial about its integrity or whether anything has happened to it. It's also about making sure that you have the ability to understand other ways of doing discovery. In the event that a court comes in and says, the way that you've done it for the other 99% of those cases, that's not going to work here. We need you to do it this way. Having those reference materials on hand, have an understanding, here's what we need to do. Here's what we need to do in any event. And it really is helpful, because there may be those cases where you have to do something in a slightly different way. Finally, what we find as part of a good discovery response process is being able to document that process for your outside counsel. Here is how we conduct eDiscovery or discovery in general at our organization? What are the expectations you have for outside counsel? It may be that your outside counsel largely directs eDiscovery for you. I would want to see the process that they follow too, to have some sense of that. If they're in effect your counsel who's executing a discovery response process. In the event that they're taking your lead on it, having something to them and say, here's what we expect you to do as our outside counsel, really helps to make sure that you're all on the same page, that the lawyer's not going to do anything to negotiate a scope of discovery that's not really reasonable, and that you're all on the same page about everything. Next slide. So the other part of a good discovery response process is really understanding where everything is. And that's why having a data map is also, we think, a very important piece of litigation readiness. Now, the challenge is there are a ton of different kinds of data maps that are out there. IT may keep a comprehensive data map right down to the memory of the copier at the corner on the 4th floor. So you know where every piece of data might live within the entire organization. For litigation, you may not need that. You may not need all of that information. A lot of organizations, a lot of legal departments, we find they need to have, what are the repositories that are most likely discovered against? Where do we find most relevant information? Let's go out and make those part of our map, and then let's add as we get new requests come in for other types of repositories. Here's the reason why that's so important. It is important on the one hand because it helps the folks in legal, those of you who are in the legal department, but also those that you work with in legal, it helps them to understand where to go to find that information. But even more important, to have a meet and confer, to have a discovery conference, either with the judge or with outside counsel or with opposing counsel, or even with a vendor that you may hire. Having a resource that talks about the repositories and gives information for them on how much data is included here. Is there a capability of placing a legal hold on this system? Is this system deleting records? Do we have to put a legal hold on it now to preserve records that might be relevant? How long has this system been in existence? Is the company planning to go with a new system? And if so, how is it going to manage the information? That all of this type of information is what allows lawyers, whether you're inside or outside, it allows you to negotiate that fair scope of discovery. The more you can tell the other party, or at least the more, let me back up, the more you know about how your repositories operate and the types of information they hold, the more powerful you'll be in negotiating with the other side and what's available, what's not available, what you can understand, and what you can tell to either the other side or outside counsel. So having this type of discovery map, we think, is incredibly useful. Now, there are, again, listed here as a records and content management. It may be that your data map is a combination. It could be a legal eDiscovery map. It could be a records and content management map that says, here's our record retention schedule. Where are all the places where that content, where those records happen to live? Again, there are a number of different ones we're starting to see now. Well, we've seen with GDPR, and we're going to be seeing with California privacy, data maps of sorts that are being developed around personal data inventories. So understanding where information is located has benefits for a number of contexts, not the least of which is going to be litigation readiness.
So, Tom, if I can understand this, if an organization creates a personal data inventory to comply with California Consumer Privacy Act, and we had a webinar on that last week or so, you could use that information to help you with eDiscovery, or vice versa. If you did an eDiscovery map, you'd be able to use it for either European privacy with GDPR or California privacy or other states' privacy. Is that correct?
I'm going to give the lawyer's traditional response of, it depends. I think the better way to put it is you can leverage a data map that you create towards eDiscovery. Some of the things that I just talked about that are important in a eDiscovery data map, tend to not be there as far as a personal data inventory. You might have location where information is so you can go find it, but it may not go into as much detail about where it is, how long it's been there. You may need more information. So I think that's kind of why we talked about the different things that are out there. Sometimes organizations would like to try to keep some of these things together, put them into a database so that you can slice and dice it how you need to. So maybe the privacy people need a personal data inventory, and they can go and call out a report that gives them that information. But from the same database, legal can go and say, I need to see all the systems that have employment-related information in them, and then that brings you back all the information you need to be able to respond to a request for information in litigation or a regulatory investigation. So I think it depends. There's certainly a lot of connections to them and a lot of uses you can make of all of them together, but they're all going to contain slightly different information. So one of the last things we want to talk about is investing in technology. What are some of the reasons why you might want to do that? Now, I think the first thing I'm going to say is that if you are in that list that we saw earlier where you are getting 1 to 5 lawsuits per year, then it probably doesn't make a lot of financial sense to go out and purchase the eDiscovery software. If you are tending to get more, if you find that the burden of responding to discovery is more painful than you would like it to be, then that may be the time that you want to look at, is there a tool that can help this process? So here are a couple of ways that technology can help. Clearly, you're getting the technology to build that consistency and defensibility. Everything about the discovery response process is about consistency, repeatability, defensibility. And the technology really isn't any different. One area that we find organizations really starting to make the leap into technology is in managing legal holds. A lot of organizations are still keeping their legal holds and tracking them on a spreadsheet, but they might not be tracking them amongst, if you have a number of what we call frequent flyers, people who are on multiple legal holds. Spreadsheets don't always have a good way of tracking that, or organizations forget, we need to track that or be able to pay attention to that, and they wind up putting a person's name 5 or 6, 7 times in the same spreadsheet. So spreadsheets tend to not be the best tools for tracking. There are a number of legal hold tools that are out there that will automatically send out the notices. They will track response and acknowledgement. They will plug into your identification system so you can easily find people on the network, put them on hold. It will send out reminders. It will send out releases. There are some tools that will actually help with the collection or identification process as well. These are great tools to have if legal hold is something that you do a lot of, that you send out a lot, that you need to keep track of them. There are some relatively cost-effective tools on the market that can help with that. Now, one thing that we talk about is whether or not there needs to be a central location for information. If you are an organization that would prefer, a lot of organizations will go in and instead of putting a preserve in place, they will do what is called collect to preserve. So we're going to gather all the information that's relevant, and then we're going to put it somewhere until it's time to produce it. Now the question is, do you try and cull it first, or do you need to wait? Sometimes you may not know exactly what your search terms are, and you may decide to pull up a lot of information. A lot of organizations find that it's useful to have a centralized repository of that information, so that they can understand where to keep it. It can be separate and apart. It won't be touched. It'll be sort of a pristine copy for information. And I think the other benefit to having that is, if you are in an industry that gets frequently sued on certain matters, there may be certain types of information that you always want to keep under some type of hold or a copy of, so that it's easy to get to. And being able to, you can minimize keeping different extra copies of that information if you have a centralized repository for that. Well, and one last thing from the last slide is, having a good collection tool is also important. Being able to go out and collect information, whether you're collecting it from your email, whether you're collecting it from file shares, whether you're going out on systems and getting information, understanding the best ways to collect information is really going to be critically important. A lot of organizations have relatively inexpensive tools that can do that. Office 365's eDiscovery module has the capability of doing that with your email, with your Microsoft documents, and what you have on your file shares and in SharePoint. But there are other tools that also are dedicated specifically for that purpose. We get a lot of questions about whether or not there is it's beneficial to have what we would call an all-in-one solution. Is there one-stop shopping for an eDiscovery tool? There are a number of end-to-end tools that are out there that will start you off from the identification to legal hold through collection and preservation, and it'll even process the data. It'll help you review it. It'll help you produce it at the back end. A lot of these systems, the benefits obviously is you're dealing with a single vendor, so that's easy. A lot of these tools are very complicated and expensive to implement. So we don't see this happen all the time. Most of the organizations who do it have very heavy litigation profiles. What we see happening more often is we see organizations who purchase tools that sort of bolt onto each other. So the vendors are coming up with ways now to make a legal hold tool work with a collection tool from another vendor. And there's lots of plugins and connectors that can be used. And that way you can find out what you need to do, what's really important to you, and buy the right technology that's right for you. So what did we learn today? We learned that you've all got litigation, and those of you who have less litigation are more at risk than other organizations. You do have, while you don't have control over when you get sued, how you get sued, by who, or how much for, you definitely have control over that process and your readiness when you are sued. Not just because you're in the public sector and you may not get sued in a number of things doesn't mean that you will not get the same types of requests for information, just in the form of a public record request or FOIA or some other type of request, of privacy-related things. We believe that the best way to deal with this is to develop a litigation readiness program, a litigation readiness process that will help you respond by not having to reinvent the wheel every time, by not having a fire drill and knowing here are the steps I need to follow every time that comes along. While we believe that just having that defensible process in place goes a really long way towards making you litigation ready, there's also a number of technology tools that are out there that can help with that as well, depending again on your profile and your volume of litigation.
All right, Tom, that brings us to the end of this webinar. Just briefly about Contoral. You may know of us already. We're the largest independent provider of information governance consulting. As you can guess, we not only help a lot of organizations with records management or control of privacy, other sensitive information. We also, quite frankly, do a whole lot of work around litigation readiness, helping companies implement a lot of the policies and processes and tools that we've talked about in this webinar. We work with more than 30% of the Fortune 500, but we also work with many, many small, mid-sized organizations, federal agencies, and public sector. And as you can tell, our emphasis is really on having a real impact out there. We have a lot of content out there, a lot of very popular, very useful content. A new white paper available right now, Building a Modern Information Governance Strategy. This is a good overview of information governance and what we're doing. So email us info@contoral.com. We'd be happy to be able to send you this white paper that talks about really what is how do we take a more modern approach to all these things, and we alluded to some of those topics here today. And then our next webinar will be on Wednesday, November 14th. We've talked about it. This is really important, implementing data placement and defensible deletion. Once you have your policies and once you have some of the technology, how do you make it work? How do you get employees out of this manual process for saving information? And how do you implement legal holds, all the things that we talk about? This sort of brings a lot of these pieces together. That's going to be on Wednesday, November 14th. And then December 13th, driving employee behavior change management. Can't talk about that, how important that is. And again, all the webinars in the series are available for review if you want to spend your weekends going through webinars. Happy to have you be able to replay those webinars. Tom, I want to thank you today for your comments and your input, and thank you very much for really thoughtful areas on litigation readiness. We appreciate that.
Thank you very much. Appreciate it. Good luck, everybody.
And then likewise, do spend just 30 seconds filling out the survey. We obsess over, we want to make sure that we're getting you the right content. Was this the right level? Too much, too little? Good content, not the right content? Just let us know. So as we do more of these, we can get the information at the right level in the right way that's most useful for them. So with that, I want to thank you for attending today and wish you success with your litigation readiness.